Welcome back, courtroom watchers. Today we're inside Judge Raquel West's courtroom, and trust me, this one's going to test everyone's limits. For defendants, for stories of second chances, and one judge who's officially out of patience. We've got theft, probation violations, and emotional confessions that'll leave you wondering who's really ready to change and who's just hoping for mercy. Watch closely, because every word matters in this courtroom, and one wrong answer could mean months behind bars. Buckle up, this is real justice, unscripted.
2, 3, 4, 1, 13. 2, 3, 4, 1, 13. Okay. 2, 3, 12, 13.
3, 12.
13.
I was eavesdropping. Okay, Miss, again, you're Crystal Moore. And Mr. Rojas, will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Moore, in cause number 25 DCCR 0496, you're charged with that's the new offense. You're charged with theft of property with previous convictions, a state jail felony from December 26th of 2024. That indictment alleges that you were previously convicted of theft April 28th of 2017, and then after that was final, March 5th of 2024. And how do you plead to that charge? Are those two prior convictions true?
What you're hearing right now is Crystal Moore entering a guilty plea to theft with prior convictions. And yes, that's serious. Under Texas law, prior theft convictions elevate what might have been a misdemeanor into a state jail felony. The judge confirms Moore's plea is freely and voluntarily given, meaning no coercion, no confusion. It's also crucial that she understands this plea waives her right to appeal. That's permanent. If she regrets this tomorrow, there's no redo. What do you think? Is she accepting responsibility or just going through the motions to get it over with?
Did you enter your plea of guilty freely and voluntarily? Yes. And did you plead guilty because you actually did what they charged you with? Yes. I have some documents in that case here on the computer that this has your signature on it, that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Yes. Do you fully understand them? Yes. And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Yes. Okay, so it looks like we are
proceeding on
off of the
counts.
ISF issue or whatever.
Oh, okay.
Right?
I don't think that was ever.
That wasn't this one. Okay, gotcha. Sorry, I don't know why I'm getting so confused. Again, but before you signed these, you went over them with Mr. Rojas? Yeah. All right. And do you understand, if I follow the agreement, that you'll be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement that you made. You understand? Yes. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Moore is not competent?
No, Your Honor.
All right, ma'am. In cause number 25 DCCR 0496, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It's my understanding that the state has taken into consideration under Section 1245 of the Penal Code that unfiled possession of a controlled substance, which means, Mr. Coleman, y'all do not plan on filing that. Is that correct?
That is correct, Judge.
All right. So then,
There it is, 21 months in state jail. The judge's tone says it all. Businesslike, no drama, but firm. Notice how she double-checks competence and voluntariness before sentencing. That's not just politeness. It protects the record from appeal. The sentence also credits Moore's time served, a small but meaningful detail for defendants already behind bars. For many viewers, 21 months may sound light. But remember, This is a state jail felony, not a full prison term, and those facilities are no vocation. Question for you. Do you think repeat theft offenders deserve shorter or longer sentences when they keep reoffending?
In cause number 23, DCCR 2026, give me just a second. I have a motion to revoke your first amended motion to revoke your community supervision in that case. Shows that you were placed on probation April 29th of 2024 for the offense of driving while intoxicated with a child under 15, a state jail felony. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
The state has elected, or the agreement that you've reached is for me to go forward in that motion with counts 2, 3, 12, and 13. Is that correct?
Yes.
Yes, Your Honor. And the state would abandon the remaining.
Thank you, Mr. Coleman. Ms. Moore, count 2 alleges that you violated your probation in that you were in Calcasieu Parish, Louisiana on the 22nd day of November 2024 without permission. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample October 9th of 2024 that tested positive for benzodiazepine and tetrahydrocannabinol. And is that true or not true?
True.
Count 12 alleges that you committed the new offense of theft of property October 18th of 2024. And is that true or not true?
True.
This is where things spiral. The prosecutor lists multiple probation violations, leaving the state without permission, failing drug tests, and committing new offenses while still on probation. That's basically the holy trinity of don't do this. Each true admission locks her deeper into revocation territory. What's interesting is how calmly she agrees. No excuses, no push. It's like she knows what's coming. When probation is revoked, that suspended sentence comes roaring back. Moore's facing the exact same term she thought she'd avoided months ago. Ever wonder if you were the judge? Would you give her another chance? Or say, enough's enough?
And count 13 alleges that you committed the offense of possession of a controlled substance February 16th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 12, and 13 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
So I also have paperwork here on the computer in that case that has your signature on it that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes.
Do you fully understand it as well?
Yes.
And you also understand that if I follow this agreement that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Ms. Moore, in cause number 23, DCCR 2026, I'm going to find that you entered your pleas of true to counts 2, 3, 12, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find sufficient evidence to revoke your probation, and at this time revoke your probation and reassess your punishment to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive, and it will run concurrently, this case, with cause number 25, DCCR 0496. In each of your cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We went over that not that long ago when you were placed on probation the first time, right? Do you recall that?
Yes.
Okay, so you're obviously, because of the judgments entered against you, you're ineligible to possess a firearm in the state of Texas. We've already gone over it. Make sure you read it. If you have any questions about it, talk to Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. Okay, that's done. That's done.
Yes, Your Honor.
Okay. Thank you, Ms. Malfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Give me just a second to get it up. Mr. Jackson, in cause number 20, all right, y'all marked third degree on the paperwork, but the indictment says second. I just want to make sure it's the mark correctly.
I just looked at it sideways.
Okay, so that should be second degree.
Yes, Your Honor.
If with everybody's permission, I'll make that change on the paperwork.
Yes.
Okay.
And apologies for my handwriting because it's horrible. on the
It's,
tablet.
well, it's hard on the tablet. You're good. All right, so you're charged in cause number 25 DCCR 0114 with the second degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment or like ISF or something like that. And it looks like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Now, let's shift to Camden Jackson, just 19 years old, pleading guilty to organized criminal activity. That's no small charge. The DA wants a 7-year deferred probation, meaning no conviction yet if he behaves. But Judge West isn't impressed. She's got reports of jail, misbehavior, fights, and defiance, the kind that wrecks plea deals. Her warning, crystal clear. One more incident, and this offer's gone. That's legal reality. Deferred sentences are a privilege, not a right. The judge is giving him a lifeline, but also a leash. Think he can stay out of trouble for 7 years?
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick, jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with a co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment of if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been
Yes.
absolutely ridiculous acting up in the jail.
Yes.
So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing all the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it. The jail's sick of it. And I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One, we're not going to come in and say it was somebody else's fault. I only got one, or I got three, and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
Thank you, Your Honor.
Yes, sir. Yeah, the last one was May 17th. So.
If you're enjoying these real courtroom moments, make sure to hit that subscribe button and turn on notifications. We've got more unbelievable cases, shocking rulings, and raw courtroom trauma you won't find anywhere else.
All right, Peyton Woodruff, 2 cases. All right, good morning, ma'am. Are you Peyton Woodruff? Yes, ma'am. What is happening to everything? I don't know.
It's just done things by itself.
All right, will your client waive the formal reading of the indictment in each case?
She will.
Ms. Taylor, in
This
cause,
is Ms. Woodruff.
I'm sorry, Ms. Woodruff, excuse me. Ms. Woodruff, let me get rid of that right now. Did I not? Hold on. Did I not send you both of those documents on Ms. Taylor?
I think I accidentally sent it back to you when I signed the judge. Oh, because you were missing a signature. Yes.
Okay, there it is, back to you. All right, now, that's not going to confuse me. Okay, she'll waive the formal reading in each case.
So wait, Your Honor.
Ms. Woodruff, in cause number 24, DCCR 1710, you're charged with the state jail felony offense of burglary of a building from June 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
And cause number 25, DCCR 0426. You are charged with the second-degree felony offense of robbery from February 22nd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
In each of these cases, I have here on the computer documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And it looks like there is no agreement. This is just open plea to the court. Is that correct?
That's correct, Your Honor.
Yes, Judge.
Do you understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is you can let them determine, obviously, if you're guilty or not, and then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that and leaving your punishment up to me, and is that what you want me to do?
This one's a bold move. Peyton Woodruff pleads guilty to burglary and robbery without any deal in place. What lawyers call an open plea. That means the judge alone decides her sentence. It's a high-risk, high-reward strategy that sometimes signals genuine remorse or desperation. Judge West orders a pre-sentence investigation to dig into her background before deciding punishment. In Texas, that report can reveal everything from addiction struggles to family trauma. For the audience, do you think this open plea approach helps defendants appear more accountable, or does it just hand the power entirely to the bench?
Yes, sir.
All right, state tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Woodruff is not competent?
Your Honor, I've counseled with her and met with her on several occasions, and I believe that she's mentally competent.
All right, then, at this time, Ms. Woodruff, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Your Honor, if I may, she has a bond that was increased.
I'm not going to consider based on that plea agreement,
I
or the lack of a plea
I
agreement.
told Ms. Woodruff I'd request.
Yeah, no, let's wait and see what happens at sentencing. Okay, you can go back with the bailiff. Okay, again, ma'am, you are Stephanie Moore.
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Just a second to get it pulled up. Okay. Ms. Moore, I have before me a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 8th of 2011 for the offense of robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department January 2nd, January 24th, February 6th, and February 22nd of 2018. And is that true or not
Yes,
true?
ma'am.
True or not
I'm
true?
sorry.
That's okay. And then count 2 alleges that you provided a urine sample September 19th of 2017 that tested positive for methamphetamine. And is that true or
Yes,
not
ma'am.
true?
Yes, ma'am, it's true.
And then count 3 alleges that you were behind in your court assessed fees. And is that true or not true?
True, yes, ma'am.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am, I did.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. Revoke your probation. I'm not going to do that today. I'm going to reset your case, like I said, talked about before. We'll get the probation department to do a updated or a pre-sentence report, see what's been going on, give them all the information. Then we'll come back at a later date and figure out what we can do.
Yes, ma'am.
All right.
Thank you.
Yes, ma'am. You go back with the bailiff.
Thank you. I need to print her. Sorry.
Is that what you were trying to say?
What a session inside Judge Raquel West's courtroom. We saw Peyton Woodruff face the consequences of breaking probation again and again, a reminder that the court's patience doesn't last forever. Then came Crystal Moore, whose choices put her own child at risk, forcing the judge to deliver a powerful message about responsibility in parenting. Stephanie Moore's struggle with addiction and missed programs showed how hard recovery can be, but also how accountability is the first real step toward change. And finally, Camden Jackson learned that theft and resisting arrest don't just bring charges, they bring judgment, reflection, and a harsh reality check. Judge Raquel West didn't hold back on any of them. No sugarcoating, no sympathy for excuses, just truth, justice, and tough lessons that hit harder than any sentence. If you found this breakdown powerful, make sure to like, subscribe, and share. Every case tells a story, and we'll be here to break them down, one courtroom at a time.
What a day inside Judge Raquel West's courtroom, where excuses go to die and accountability takes center stage. We saw Crystal Moore face her past, Camden Jackson warned about his future, and Peyton Woodruff standing alone without a deal. Each case reminds us that justice isn't just about punishment, it's about choices, consequences, and whether people truly want to change. If you found this breakdown as gripping as we did, hit that like button, drop your thoughts in the comments, who deserved the toughest sentence today. And don't forget to subscribe for more jaw-dropping courtroom moments, legal insights, and real-world justice, one case at a time.